It's a real privilege for me to welcome you to this symposium, Feminist Practice, Feminist Theory, Women's Experience, Challenging Boundaries in Legal Education, co-sponsored by Northeastern University School of Law and the Harvard Journal of Law and Gender. This symposium honors Clare Dalton's contributions as a scholar and an advocate. But by honoring Clare, we also honor many other people who have fought to bring women's voices forward, who have delved into both the theory and the practice of feminism and law, and who have committed themselves to fighting for justice in a world where abuse persists. We gather today to celebrate Clare's work, but also to celebrate our collective capacity to move forward, building on the foundations both in theory and in practice that have been developed by Clare and by other people in this room over the past 25 years. This is a celebration of challenging boundaries, a celebration not only of the past, but of the future, an acknowledgement of the meaning of relationships in the world in which we work and live, and an announcement of a continuing commitment to telling stories and locating the possibilities for change, from the domains of law schools to the issues of domestic violence to the global challenges facing women. But I'd like to start us off with the first law review article Clare wrote as an assistant professor at Harvard Law School, an essay in the deconstruction of contract doctrine published in 1985 in the Yale Law Journal. The article starts out this way. Law, like every other cultural institution, is a place where we tell one another stories about our relationships with ourselves, one another, and authority. In this, law is no different from the Boston Globe, the CBS Evening News, Mother Jones, or a law school faculty meeting. When we tell one another stories, we use languages and themes that different pieces of the culture make available to us, and that limit the stories we can tell. Since our stories influence how we imagine as well as how we describe our relationships, our stories also limit who we can be. And she continued in this article by examining the rules of contract law as applied by judges and elaborated by commentators. I ask whether we can begin to understand the particular limits law stories impose on the twin projects of self-definition and self-understanding. Can we, in other words, expose the way law shapes all stories into particular patterns of telling, favors certain stories and disfavors others, or even makes it impossible to tell certain kinds of stories? And Clare closed the epilogue to the article this way. By telling my story, I also hope to open the way for other stories, new accounts of how the problems of power and knowledge concretely hamper our ability to live with one another in society. My story both asks why those problems are not currently addressed by doctrine and traditional doctrinal analysis, and suggests how they might be. By presenting doctrine as a human effort at world-making, my story focuses fresh attention on those to whom we give the power to shape our world. My story requires that we develop new understandings of our world makers as we create them, and are in turn created by them. This kind of inquiry, exemplified for me by feminist theory, can help us see that the world portrayed by traditional doctrinal analysis is already not the world we live in, and is certainly not the only possible world for us to live in. And in coming to that realization, we increase our chances of building our world anew. Today, we continue our conversations about building our world anew. In this article, we can see Clare bringing feminism and feminist theory and critical thinking to the legal academy 25 years ago, as some of the rest of you did as well. And in the article, we see law professor as storyteller. And we see the roots of our fight against domestic violence as the theoretical is brought to bear on the real world of women's stories. Like many path-breaking articles, this one has been cited often. This particular article, and I checked this morning, was cited 609 times according to Google Scholar. Actually a remarkable number, but perhaps more remarkable for a 1985 article, it is still being cited today in 2010. This article accomplished many things, but of course it didn't accomplish one thing of note. It didn't get her tenure at Harvard. So I suppose one might argue that it was in part responsible for Clare's arrival here at Northeastern. Having sued Harvard successfully, Clare brought to Northeastern not only her tremendous personal capabilities, but also the settlement money from her lawsuit, using those resources to help us start the Domestic Violence Institute here. In some ways, Clare's work in domestic violence has been the most obviously influential, moving not only academics, but also judges and practitioners to think about new and better ways to address abuse. In this, of course, she has had many partners, including many of you in the room today. But despite the hard work on this and many fronts, we cannot declare victory, sadly, not even close. What we can do is celebrate progress and dig in for the next round. Some of the speakers here today knew Clare well, others did not. But they all share the key characteristics that motivated us to convene this symposium. A commitment to feminism and to the lives of women, an understanding of the critical links between theory and practice, a willingness to challenge the boundaries of existing law and practice. Someone asked me why we have a panel on global issues, when Clare never really addressed global issues in her work. And it is true that Clare often focused on the local and the personal. But this is a symposium about women and boundaries, and today we understand that these issues are shared across the globe. This symposium is intended to be about the future and not simply a celebration of the past. And so that I hope that we accomplish two things today: a celebration of the past and an invigoration of our work for the future. I'd like to turn the podium over now to Kimberly Lucas from the Harvard Journal of Law and Gender, our co-sponsor for this event. Kimberly.
Good morning. On behalf of the Harvard Journal of Law and Gender, I'd like to thank the organizers for having the journal as a co-sponsor and for hosting this wonderful symposium. The Harvard Journal of Law and Gender, or JLG, is devoted to the advancement of feminist jurisprudence and the study of law and gender. By combining political, economic, historical, sociological, and legal perspectives, we seek to clarify legal issues that have gendered aspects and implications, and to confront new challenges to full social equality. The Harvard Journal of Law and Gender, originally the Harvard Women's Law Journal, is the nation's oldest continuously publishing feminist law journal. The founding members of the journal published the first issue of essays on women in the law as part of Celebration 25, a recognition of the class of 1953, Harvard Law School's first graduating class that included women graduates. The founding members' objective of creating a feminist jurisprudence still drives the JLG today. JLG seeks both to promote discussion within feminist and progressive communities and to bring about legal and social reform. We work to achieve gender equality for all people. We at the Journal greatly admire Professor Clare Dalton's contributions to the field of feminist jurisprudence and domestic violence law. Her ability to weave legal theory into legal practice, as well as her commitment to legal education, are truly inspiring. Professor Dalton's courage in founding the Domestic Violence Institute paved the way for a much-needed focus on family and intimate partner violence in law schools and in society. As the speakers and panelists at today's symposium will show, the legal academy and the legal profession can both benefit greatly from innovators who are willing to defy boundaries and find solutions that combine the theoretical and the pragmatic. We're happy to join the celebration of a true innovator, and we look forward to seeing how crossing boundaries can move us even further towards true gender equality. And finally, I hope you will all join us for the Journal's 2011 symposium entitled Sexual and Reproductive Rights, Barriers to Access, Roadmaps to Fulfillment. It'll be taking place on the Harvard Law School campus on March 4th, and I don't know if there's any information on the website right now, but probably in a month or two there should be more information at www.law.harvard.edu/students/orgs/JLG. Thank you so much.
So I'm Martha Davis. I'm a professor at Northeastern and Associate Dean for Clinical and Experiential Education here. And our first panel is Women and Global Issues. Emily already gave us an explanation of why we're having this panel, so I won't go into that to any great degree, except to note that usually at conferences they build up to the global view. And here we're thinking big from the very beginning, and then we'll move on from this. So we're very lucky to have three incredible speakers to help us think about how a global perspective can reframe analysis, advocacy, and teaching relating to gender equality, particularly to violence against women, which each of them are going to address to some extent. And these folks who are up here with me have been aren't just people that we found in the AALS directory. These are people that were carefully selected because of their engagement with both theory and practice. So we're thrilled to have folks that bring these particular characteristics. So let me introduce them, and then we're going to have each of them will speak for 10 to 15 minutes, and then we'll have a time for questions and discussion. So in the order they're going to speak, and also starting on my far right, Vicki Jackson, is a visiting professor at Harvard Law School with a permanent appointment at Georgetown Law School. She's a leading feminist scholar and comparativist, whose writings have been incredibly influential across a range of issue areas. And with Mark Tushnet, she's co-author of a casebook, Comparative Constitutional Law. She's a former Deputy Assistant Attorney General in the Office of Legal Counsel, and she has the distinction of having clerked at the Federal District Court, the Second Circuit, and with Justice Thurgood Marshall, U.S. Supreme Court, so she's seen it all. Lisa Crooms, to my immediate right, is professor at Howard Law School. Lisa is known for her scholarly work on critical race and feminist theory, and also for her leadership in efforts to bring human rights home to the United States. She's one of the founders of the U.S. Human Rights Network, and she continues to be a leader in that coalition. She's also the co-author with Northeastern's own Libby Adler and several others of a casebook called Mary Jo Frug's Women in the Law. And then Carrie Bettinger-Lopez, in the middle here, is an associate professor of law at the University of Miami, where she is the founding director of the law school's Human Rights Clinic, which hasn't actually opened yet, but is starting January 2011, so she's busy. She was previously acting director of the Columbia Human Rights Clinic and worked at Columbia for a number of years, and before that she was an attorney with the ACLU. And one of her major cases is currently a petition filed by Jessica Gonzalez, who litigated the Castle Rock case, and the petition that she's working on now is before the Inter-American Court. So, and I think she'll be addressing that during her remarks. So why don't we go ahead and start with Vicki and move on from there. Thank you.
Well, thank you, Martha, for that very generous introduction. Let me thank everybody responsible for inviting me and for making this possible. I was thinking that Clare Dalton's life and work have involved boundary crossing in so many ways, sort of disciplinarily and educationally. And I feel very fortunate to be able to help honor her this morning by taking up the question of whether crossing boundaries in terms of legal sources can inform constitutional law about women and gender equality. And if you will allow me, it just recently came out. This is my own little book about constitutional engagement in a transnational era, in which I discuss this question in a number of contexts, if you happen to be interested. This morning, if time permits, and if you'll let me talk fast enough, I hope to talk about three topic areas. First, federalism and gender-motivated violence, the Morrison case. Second, citizenship, including the Wen case, and maybe Flores Villar, where Professor Davis filed an excellent amicus brief, and the question of abortion, which I think is very complicated. So fitting this all into 15 minutes, we'll see. Now, I also, in the course of this, want to talk both about why I think comparative focus is helpful and legitimate, but at the same time identify for us some of the risks and costs of comparative analysis. So on the benefit side, I think there are three that might be particularly salient with respect to equality claims. And here we're talking about gender, but other. And that is that equality claims for persons tend to involve what are, at that time and context, outsider claims. They're outsider claims challenging existing structures of power that may seem very natural to those who are benefited by the existing distribution. Looking outside, seeing the world through a variety of different lenses can help unsettle that sense of naturalness. Second reason, the movement for gender equality has been a transnational movement, at least since the 19th century. I don't know about earlier. And so the changes in attitudes, the changes in laws that have occurred in the United States have operated at times behind, at times ahead, in parallel with movements and changes in other countries. And third, since World War II, many more national constitutions have been adopted, new constitutional regimes that from their beginning value both liberty and equality. We have a constitution that starts out as a constitution of liberty, at least for some people, but that is probably the central human value in that initial 1789 constitution. Equality comes in later, 13th, 14th, 15th, 19th, and so forth. And one of the challenges I think we still face more than maybe some others is how to integrate these two value commitments. So looking at constitutions that have had to integrate those two values from the very beginning, from the beginning of their constitutional regime, for example, Canada, I think can be especially helpful. Now, there are a number of other more general benefits of comparison. I'm not going to have time to mention all of them. I will mention, however, four. One is, as we saw in Muller and Oregon, the case from 1906-8 or so that upheld protective labor legislation for women at a time when, for most people, this was a progressive move. The Brandeis Brief invoked foreign experience to a great extent. It was foreign experience and social science, expanding judges' thinking, making them more reflective in light of others. The second possibility is that comparison can help check morally and constitutionally horrific choices, maybe. Here I'm thinking mostly of great dissents. Harlan's dissent, first Harlan's dissent in Plessy against Ferguson. That was the case in the 1890s that upheld segregation. In the dissent, Harlan at one point says, "We like to boast of our freedom above all other peoples, but we will not deserve that boast if we uphold this law." Outsider perspective. And Justice Frank Murphy's dissent in the Korematsu case, he said, "Look at Little Britain. It's a lot smaller than us. They've got almost as many enemy aliens, and they're giving individualized hearings to each one. They're releasing 64,000 and incarcerating only 2,000. We could be doing that too, instead of associating group guilt with a racial group." Now, last point I guess I will make is that I think in the world we live in, comparison is completely inevitable. And people will have mistaken understandings as well as correct ones. Write it down, expose it to the world. Thus, when Chief Justice Berger in the Bowers case wrote that homosexuality was universally condemned in Western civilization, it opened the door for other people to say, as the court in Lawrence said, actually 2 years ago, before Bowers, the European Court of Human Rights had struck down a sodomy law in Ireland as inconsistent with basic human rights protected in the European Convention. All right, now, let's come to the Morrison case. Am I going totally too fast? No. All right. Let's
educated audience here.
Okay. Now, in Morrison, as you know, the question was whether the federal government had power to have enacted the civil rights cause of action for gender-motivated assaults. The Supreme Court held no. Now, in some ways, the issue was a peculiar one of U.S. federalism. And it is particularly difficult to do comparative work across federal systems because federal constitutions are always a very specific compromise between existing power holders. They involve interdependent balances of powers. Each provision is nestled in an overall package generally aimed at some sort of balance. And there is no international archetype for what a good federal allocation is, the way there is for human rights. Nonetheless, even on the federalism issue, if you look, there might have been something to learn from Canada. Canada, like the United States, had a structural constitution that didn't deal with rights, except language rights at all, from 1867, judicially enforced. 1982, they adopt a Charter of Rights, enforceable constitutional rights, liberty, equality, all of those good things. The issue arose a couple of years before Morrison whether the national government there had power to enact a national firearms registration law. And the chief judge of the Alberta Court of Appeals, this is like the First Circuit or the Second Circuit, the chief judge of the Alberta Court of Appeals said that the Charter's value of equality, particularly gender equality, had what she called a pollinating effect on the entire constitutional structure. And given the damage of domestic violence and the data suggesting that gun ownership in the homes was associated with women being killed or injured through use of those guns, she thought this was legitimate to take into account in understanding the scope of the federal power over criminal law from 1867. Now, there are many points of disanalogy here. But if you look at it in sort of broad terms, I found a sentence in my book that said this reasonably well, so I thought I would find it. I think this case supports the idea that the equality norms most highly protected in our 14th Amendment, including strict or close to strict scrutiny for gender as well as race, should be understood to inform the power to regulate commerce, to permit Congress to rely on longer chains of inference when it exercises the commerce power to redress racial or gender inequalities that serve as barriers to the full and equal participation of those groups in the national economy. This argument was implicitly made in an amicus brief that I was involved in, but we didn't think to look at other law. It might have been interesting, not because we should do what Canada did. Because what Canada did reminds me, and should have reminded the court, I think, of what the court did, our court did in Heart of Atlanta Motel in the 1960s when it upheld the Civil Rights Act of 1964's application to acts of private racial discrimination by restaurant owners and hotel owners. Okay, so that's one point. Now, could foreign law have been relevant on what the 14th Amendment meant? Certainly, but we had a problem of indigenously developed doctrine, the state action doctrine. Long-standing, way back, something of a barrier. I don't think I have time to talk about the treaty issue, which the court simply ignored in that case, but maybe not surprisingly, notwithstanding a very good amicus brief about gender equality and the Iccpr, which we had ratified. Joe Biden never referred to the Iccpr so far as I could tell, and so it might have struck the court as a little far-fetched. Let me move on now to the Wen case. In 2001, this was a case where, to my surprise, the Supreme Court, allegedly applying intermediate scrutiny, upheld a gender classification in our citizenship laws. Basically, the law said that children born abroad to unmarried U.S. citizens' mothers who had spent some time in the U.S., could automatically be U.S. citizens. But children born abroad to, who were the children of unmarried U.S. citizen fathers had many additional burdens, one of which was for the father to have established paternity legally before the child reached the age of 18. This was a situation where the child was raised by the U.S. father in Texas from the age of 6, no question of paternity, not a very wealthy family that would spend lots of money on legal things. Kid gets the person commits crimes, is going to be deported as an alien. Dad establishes paternity. The kid is 22 and has lived with the dad since age 6. The court upholds the requirement in this setting because it says Congress can insist on having evidence of a blood relationship, of a genetic relationship. That's a legitimate purpose. And mothers, by virtue of giving birth to their children, have an opportunity to form a relationship that fathers don't have. Opportunity to form a relationship, not the relationship itself. How is the opportunity in that sense an important governmental objective? Justice O'Connor wrote a very strong dissent, and the court ignored evidence of decisions in other countries striking down gender discriminations, including the Benner case in Canada, which had been decided 2 years earlier. The Benner case involved a discrimination that was adverse to female parents of children born abroad, And the court said in Canada, said it was inconsistent with the charter commitment to gender equality for the law to suggest that women were not equally capable of passing on whatever it takes to be a good Canadian to their children. The majority opinion in Wen gives no indication of the damage to general understandings of gender equality that having such a discriminatory classification may convey. Now, would detailed knowledge of this case have mattered? Maybe not. The U.S. law favored mothers. And in the time this case was decided, that might have seemed a lot more natural than the Canadian law that was struck down, which favored fathers. Moreover, the court in Wen seemed quite worried about how many new citizens we might get if this law were changed in the U.S., because there were so many American men traveling around the world in the U.S. military. So in other words, there was a risk of a lot more citizens coming in if the Wen case had succeeded than in the comparable Canadian case where it would have advantaged mothers. Nonetheless, the embrace by the Benner Court in Canada of the gendered meaning of this law, the meaning of this law for understanding equality, I think it would have been helpful if the court had seen it. There's a currently pending case called Flores-Villar, which involves another twist on the same statute, dealing with a requirement on U.S. fathers whose children are born abroad, which is that the father has to have been resident in the United States for at least 5 years after the age of 14. The father in Flores-Villar was 16 when he fathered the child. Not capable, there is no possibility of meeting this requirement, which did not apply to mothers. And I'm looking at Martha because she wrote another superb amicus brief discussing trends in other national constitutional courts on gender discriminations in citizenship, reporting that of the 8 decisions on these issues in recent years, all but one had rejected the constitutionality under a general equality principle of the classification. Now, Martha's excellent amicus brief leads me into my final discussion of sort of the risks and complications here. Her brief notes in the first page, quote, because the opinions of Austria, Germany, and Italy are not available in English translations, amici's discussion of these cases rely on reputable secondary sources. Perfectly reasonable. But if you're the Supreme Court, are you going to be a little nervous about relying on a description of a case you can't read? Yes. So one problem, accessibility. Problem 2, even where the materials are accessible, getting it right in another legal system is very hard. You need to understand a much broader context to have any degree of confidence that you're understanding the law. Third, is it really comparable? Even looking at Canada, there are many differences. It's a parliamentary system, not a separation of powers system. Canada's still part of the Commonwealth. We're not. There are all sorts of questions about genuine comparability. In the citizenship case, the U.S. has a huge military presence around the world. Canada doesn't. Is it really comparable? Fourth, we should recognize that comparison is not a one-way ratchet to whatever one's envisioned progressive utopia is. The world is a very diverse place. Martha describes a decision in Egypt upholding a gender classification. It was 1 of 8. Well, what if there are 16 decisions and half of them uphold and half of them don't? So it seems to me that one has to be prepared to engage with the reasoning of foreign sources. Some of it's going to make sense, some of it we're going to reject. It's not a one-way ratchet. I have argued, therefore, for a posture I call engagement. Now, I see that my time is almost up, so instead I'm going to skip most of my discussion and just give you a little bit of what I thought about on abortion. And I was thinking about this because Justice Scalia, in his dissent in Roper, which is the case striking down the juvenile death penalty in 2005, 5-4 decision, Scalia writes a very angry dissent saying it's completely illegitimate to look at foreign experience. We don't look at it elsewhere, he says. And if we did, what would we find? We would find, he says, that the U.S. is an outlier on the regulation of abortion. He says the U.S. is one of only 6 countries out of the 180 or 190 in the world that permit abortion without any reason up to the time of viability. And he relies on Center for Reproductive Rights data. Now, Is he right in a technical matter on what he said? I believe he is. I've looked at the same data. But he misses the point of the importance of context, of understanding, for example, that one of those 6 is Canada, that Britain is not in those 6, but under the British regime, abortion is available for many, many reasons, and according to people who've studied it, pretty freely available, up to roughly the same time, I think 24 weeks. But the 2 points that I would make, if I had time, and we can discuss later if you're interested, is that looking comparatively suggests to me that there are actually a range of regulatory approaches in the world among the Western constitutional democracies, or among, let me take out Western, constitutional democracies, a range of approaches that seem to me to be about as compatible with women's equality interests as the current Roe Casey regime. Second point, really important to remember, you've got both equality interests and substantive liberty interest at stake. And third, the argument that some have made that the U.S. ought to emulate some of the European approaches, which have more limited access to abortion, could be a tremendous problem here because those European countries are constitutionally committed to being social welfare states, meaning more child care, more medicine is paid for, more assistance. And we are, whatever we are not constitutionally committed at the federal level to being a social welfare state, at least yet. So I will end there, a little bit beyond my time. Let me just be clear, I favor engagement with comparative and international sources here, but I favor it in a cautious and careful way. That's it. Okay.
Good morning. Good morning. Good morning to you. Maybe I should say just morning. Thank you for giving me the opportunity to participate in this particular symposium. I would be one of those places that has cited that article, and I have to say I found great relief there when teaching contracts. So thank you. If for no other reason, thank you for that. What I want to talk about this morning is it comes out of work that I'm doing with an interdisciplinary team. I've got an anthropologist and a sociologist, and we are collectively drafting the 2011 thematic report for the UN Special Rapporteur on Violence Against Women. The theme for this year is looking at the impact of identity, personhood, and citizenship on how violence is experienced. And I'm consciously attempting to avoid using intersectionality because it is a term that is incredibly laden with a whole bunch of stuff that we actually just want to leave outside the door. So this is the first opportunity that I've had to trot some of this out. So thanks for this chance. I was one of the people who went back and looked at your casebook, and there is that section on international law. So I looked at the publication date of the last edition I have about 10 years ago, and there's an observation that's made in the book, and I quote, "The human rights effort seeks to persuade the international community that violence against women is a public issue and an issue of state dereliction of responsibility towards its citizenry, rather than a purely or merely private problem faced by individual women in their relationships with individual men. These efforts are also aimed at increasing state responsiveness to the needs of women." So, if we start there, I think we can all safely say that a lot has happened in the decade or so since those observations were made. Recently noted by Manesha Desai, who wrote one of the background papers for the 20th anniversary of the UN's Human Development Index. The title of the paper is Hope in Hard Times, Women's Empowerment and Human Development. The observation was that the trends in women's empowerment over the past 20 years or so show that there have been gains in primary and secondary education and political representation at the national level and in wage labor, and a decline in fertility and maternal mortality. It's not all good news, however, we know, right? Nevertheless, violence against women and HIV/AIDS continue to be endemic, and these trends vary across regions and within countries. Urban and rural poor, ethnic minorities, and older and disabled women fare worse on all indicators, with the current economic crisis reversing many gains. Okay, so yesterday, the 2010 Human Development Index is released. There are two additional, relatively recent events that help to further clarify the complexities of assessing just how far the human rights efforts to which the casebook refers have come to achieving their objectives. In other words, we can ask the question, is women's violence seen and treated as public rather than personal? Are states held to account for violence against women and girls perpetrated by both private actors and the state? And has state responsiveness to the needs of women and girls increased? But before we consider these two events, I need to digress slightly. In 2007, the current UN Secretary General, Ban Ki-moon, announced his Unite to End Violence Against Women campaign, hailed as a multi-year effort aimed at preventing and eliminating violence against women and girls in all parts of the world. It urges governments, civil society, women's organizations, young people, the private sector, the media, and the entire UN system to join forces in addressing the global pandemic of violence against women and girls. To this end, it identifies 5 goals that it hopes to achieve by 2015. First is to adopt and enforce national laws to address and punish all forms of violence against women and girls. Second would be to adopt and implement multi-sectoral national action plans. Third, we're going to strengthen data collection on the prevalence of violence against women and girls. Fourth, increase public awareness and social mobilization. And fifth, address sexual violence and conflict. And the fact that they segregate out that last one ends up being important to, I guess, what I have to say today. So, the first event that I want to share with you relates to that 5th goal. And then the second event relates to how the UN seeks to accomplish what it seems to be all 5 of the Unite to End Violence Against Women campaign's goals. So the first event. A little more than 2 weeks ago, the Secretary General marked the 10th anniversary of Security Council Resolution 1325 on women, peace, and security. Among the things with which that 2000 resolution was concerned was that, and I quote, civilians, particularly women and children, account for the vast majority of those adversely affected by armed conflict, including as refugees and internally displaced persons, and increasingly are targeted by combatants and armed elements. The resolution reaffirmed the need to implement fully international humanitarian and human rights law that protects the rights of women and girls during and after conflicts. So if we fast forward a decade to about 2 weeks ago, the Secretary General is lamenting the UN's failure to build sufficiently on the conceptual foundations of the Resolution 1325. He points to the fact that women still face obstacles to engagement at all stages of the peace process, and notes that sexual violence remains an all too common tactic of war and often continues well after the guns fall silent. The Secretary General announced that his Special Rapporteur on Sexual Violence, and that's not to be confused with the Special Rapporteur on Violence Against Women, would be charged with raising awareness and spurring action about, and I want to emphasize this, the need for gender mainstreaming in matters of peace and security. So that's event number 1. Event number 2. About 4 months earlier, on July 2nd, the United Nations announced the creation of UN Women, and it's actually the UN entity for gender equality and the empowerment of women. This self-described super agency on women's empowerment, and I see a cape with tights and a big W. It's a great outfit. It brings together UNIFEM, the Division for the Advancement of Women, the Office of the Special Advisor on Gender Issues, and the UN International Research and Training Institute for the Advancement of Women. So it brings together what were 4 separate entities into this super agency. Its tasks include overseeing the world body's programs aimed at promoting women's human rights and their full participation in global affairs. Like the Secretary General's redoubled efforts to mainstream gender in accordance with Resolution 1325, UN Women is supposed to serve as the type of gender focal point, advocacy for which can be traced back to the Beijing Platform for Action and perhaps even beyond that, back to Nairobi. While these announcements, I will give them their due, they deserve part of the fanfare that accompanied them. They send at best a mixed message about the extent to which the UN has made any progress toward persuading the international community that violence against women is both a public issue and an issue of state dereliction of responsibility towards its citizenry. This has meant that state responsiveness to the needs of women in these contexts is incredibly limited. So if I turn to violence against women as a public issue. Now, if we keep in mind that the Secretary General's recent admission concerns the UN's failure to address violence against women and girls in conflict and post-conflict situations, we understand that in this context, gender-based violence is more often than not conceptualized as sexual violence, which may involve trafficking and prostitution. Other types of violence, as well as women and girls with different relationships with violence and war and conflict, are pushed to the periphery, viewed as afterthoughts or outliers. In addition, the Secretary General's focus on violence against women and girls in conflict and post-conflict situations exists within a larger violence discourse which appears to segregate violence based on whether it occurs in wartime or peacetime. If it's cast in this way, peacetime violence against women and girls must be extraordinary to warrant the severe abrogation of sovereignty thought to occur when largely domestic matters become matters of international concern. This may help to explain in part why CEDAW, the Women's Convention, has the distinction of being the UN Human Rights Treaty with the most reservations. Whether asserted as a matter of cultural integrity or tradition, the ubiquitous, ordinary, and everyday violence with which most women and girls are directly or indirectly familiar is often rendered beyond the limited situations in which real and severe human rights violations occur. Like the Secretary General, UN Women appears to conceptualize these two types of violence as having little in common. An additional way in which the Secretary General's admission is telling goes to the scale of the violence and the atrocities to which the Secretary General is, in his best UN speak, referring. Here we're looking at Bosnia and Rwanda, the Democratic Republic of Congo, Sierra Leone, just to name a few. These are countries that are marked by conflicts with obscene and unspeakable violence. These are the places where the grossest and most serious human rights violations take place. And for most people, these are the images that most easily come to mind at the mention of violence, women, and human rights. Tens of thousands of women and girls in Bosnia, hundreds of thousands of women and girls in Rwanda and the Democratic Republic of Congo. While the combination of large-scale sexual assault and rape and war or conflict seem to make this type of violence against women and girls particularly heinous, it also helps to make those sexual assaults that occur outside of the context of war or conflict seem less heinous. And in the context of war and conflict, it's almost as if rape must be a spectacle in that public sort of way. So, the almost 250,000 victims of rape and sexual assault in the United States in the year 2006 alone, including the 144,000 who were raped or sexually assaulted by people they knew, trusted, or loved, for the most part are not understood to have had their human rights violated. It's just not a matter of human rights. The very public nature of the violence against women and girls as spectacle that occurs within conflict only makes the violence relatively visible, that is, more visible than the ordinary everyday violence suffered by most women and girls. What the Secretary General seems to recognize is that the UN's efforts to address this very public violence as spectacle have failed. This can't bode well, I think, for the less public, less understood violence that is largely contained by the walls within which women and girls live their lives, hidden from the gaze and the responsibility of the state. It shouldn't be understood to suggest that domestic violence is completely ignored. Indeed, domestic violence, including marital rape, is among the types of violence UN Women cites as where gender and violence merge. The point here, however, is that the analytical framework used by the UN does little to encourage a view of violence against women that spans a continuum that links intimate violence among family members to state violence within the context of war and armed conflict. The key here is to avoid viewing these two types of violence as mutually exclusive, but rather as poles anchoring a continuum of violence in which their shared foundation is essential to understanding them as manifestations of violence that may be different, but only as a matter of degree. Now, if we turn to UN Women, the gender mainstreaming superagency claims to be grounded in the vision of equality enshrined in the UN Charter and committed to work for the elimination of discrimination against women and girls, the empowerment of women, and the achievement of equality between women and men as partners and beneficiaries of development, human rights, humanitarian action, and peace and security. That's all a UN quote. The absence of violence from this list of UN Women's commitments is made even more curious by the agency's acknowledgement of the universality of violence against women and girls. Now, if you're well-versed in UN speak, then you know that UN Women's work around eliminating discrimination against women, as well as achieving equality between women and men as partners and beneficiaries, should be broad enough to protect women and girls against violence. The Beijing Platform, the Women's Convention via General Recommendation number 19, and the Declaration on the Elimination of Violence all support the idea that violence and discrimination are linked. General Recommendation 19 names gender-based violence as discrimination under CEDAW. And I'm going to skip that because I know I'm going over. And CEDAW also identifies the rights violence makes impossible for women to enjoy, which include life, equality, liberty, and security of person, equal protection under law, non-discrimination, the highest standard attainable of physical and mental health, just and favorable conditions of work, and not to be tortured or subjected to other cruel, inhuman, or degrading treatment or punishment. This list is illustrative rather than exhaustive, and it includes rights not only articulated in CEDAW, but also in the Universal Declaration of Human Rights, the Iccpr, the Economic, Social, and Cultural Rights Covenant, and the Convention Against Torture. But the point here is if you read those things and you're looking for that to be explained, it's not there. You have to dig through the official interpretations offered by the relevant treaty bodies to even find the connection between violence and discrimination so that you understand that discrimination within the meaning of the Women's Convention does recognize that violence is discriminatory. It is gender-based discrimination against women and girls. Okay, so violence is a issue of state dereliction of responsibility. Both UN Women and the Secretary General address state responsibility for addressing violence against women. The Unite campaign urges UN member states to adopt and enforce national laws to address and punish all forms of violence against women. They adopt and implement multi-sectoral national action plans. You're supposed to strengthen data collection and increase public awareness and social mobilization. This represents a positive development in breaching the divide between the public and the private. Public responsibility for violence committed by private actors is central to how state responsibilities towards its citizenry, as well as citizenship itself, are understood in this context. Public accountability for private actors' violence against women and girls was underscored in General Recommendation 19, which urges state parties to, among other things, take appropriate and effective measures to overcome all forms of gender-based violence, whether by private or public or private act. The absence of laws and policies designed to hold private citizens culpable for their violent acts operates as the fulcrum on which state responsibility for private actors' violence is balanced. Here, however, the absence of any real enforcement mechanisms makes it all too easy for the UN member states to avoid any real consequences beyond embarrassment for the injuries wrought by violence against women. Great. The concept of due diligence in the context of violence against women can be traced back to both CEDAW's General Recommendation 19 and the Violence Declaration. It seems to be the source of an affirmative state duty to prevent, investigate, and punish acts of violence against women, regardless of the status of the perpetrator. While many countries have laws on the books making violence against women a criminal offense, the extent to which such laws are enforced and their effectiveness in not merely remedying the injuries caused by violence against women, but rather preventing those injuries remains questionable and largely beyond measure. This would be part of the work undertaken by UN Women, but it's unclear whether the financial resources needed to gather the data to construct a more complete picture of violence against women as a matter of law and policy will be available for UN Women, or if the merger is thwarted by inadequate funding before it gets out of the gate. And the member states have recognized that it's going to need a minimum of $500 million to do its work. They acknowledge that there's no indication of who's ponying up to actually pledge the money, but they acknowledge that it's going to take way more money than has been dedicated to this work when it was disaggregated in the 4 separate entities, let alone trying to consolidate it. Okay, I've got this thing about acts and omissions. We can talk about that later. The only thing that I really want to get to before I get out of here is this notion of increasing state responsiveness to the needs of women and the impact of gender mainstreaming. There's a lot of talk about equality and empowerment of women vis-a-vis men. And gender mainstreaming and gender equality are important, but I think they have little to do with intra-gender differences that render certain identifiable groups of women especially vulnerable to the inequality of, in this case, violence. It's particularly troubling in light of Resolution 1325, and the fact that conflicts, more often than not, are tinged by the prejudices and paranoia, xenophobia, and the villainy of the other. Gender mainstreaming runs the risk of continuing to make intragender differences among women at best an afterthought. This is what will remain outside if gender mainstreaming remains focused on an artificially narrow notion of gender equality. And then finally, the focus on physical, mental, or sexual harm minimizes the ability to address the violence suffered as a result of extreme poverty. And the way the UN has dealt with this is that the Millennium Development Goals are where extreme poverty is dealt with, but there's little cross-fertilization to begin to look at violence from the perspective of who is injured and how. And if you start from the injury and then work backwards, the cause of the injury, it seems less important if the whole point is to provide a remedy and to, in the best of all possible circumstances, prevent further injury. If that's the case, then it shouldn't make any difference whether you're harmed because you're poor and the state knows that you're poor but continues to allow you to be poor and live in extreme poverty, or if you're suffering at the hands of an insane and crazy, or perhaps not so insane and crazy, individual who decides that they're going to pummel you every night. You're still injured. And if this is about making you whole and recognizing your full humanity, then there have got to be remedies available for the injury regardless of the source of the injury. I cut it short, but hopefully I came in within my 2 minutes. And sorry if I didn't, Carrie and Martha.
Okay, great. Hopefully my voice will hold out. I have had this.
You want me to read it for you?
Okay, I too just want to thank Northeastern Law School and the Harvard Journal and Martha Davis in particular for inviting me to be here. It's quite an honor and a privilege to be here amongst this group of people and really an exciting moment, I think. So thank you for bringing us together. I'm also going to speak fast, and I think I'm happy about the order of this panel because I think my presentation will pick up on several of the themes that have already been discussed. Just a few that I wrote down. Law is storytelling, the global as the local, and this concept of bringing it home both as in the home domestic sphere and home as in the United States. So today I'd really like to explore how Clare Dalton's orientation towards experiential and intersectional and experimental legal education applies in the field of human rights and gender justice. And I'm specifically interested in thinking about how law school clinics can serve as important sites for offering new approaches to domestic violence advocacy and largely by employing multidimensional lawyering strategies that offer an alternative legal framework. And for me, that's been international human rights and comparative and foreign law. I'll be reflecting on the experiences of teaching a human rights clinic and litigating the case of Jessica Gonzalez versus the United States, which Martha referred to, which is a domestic violence case currently before the Inter-American Commission on Human Rights. The case really became a vehicle for a larger mobilizing strategy that filled a gap in the advocacy community. And it's really spurred me to think about how a human rights approach to gender justice work might challenge a lot of the silos that have become such an ingrained part of the women's rights and gender and sexuality field in the United States and perhaps internationally. Again, picking up on a theme that some of my co-panelists have touched on. So first, I just want to talk about the Gonzalez case. Many of you are familiar with it, and Zanita Fenton will be talking about it later on. But just very briefly, this is a case involving a domestic violence victim from Colorado who in 1999 called the police and met with the police 9 times over the course of a 10-hour period after her husband kidnapped the children in violation of a restraining order. And the police, proceeded to file missing dog reports that night, go to 2-hour dinners, responding to fire lane violations, but they did not respond to Jessica's cries for help. And most of you are familiar with the tragic ending. Her husband arrived at the police station. He opened fire. The police fired back. Her 3 children were found dead in the back of the truck. Jessica sued the police under a 14th Amendment procedural due process theory, and her case went up to the U.S. Supreme Court, which in 2005 found that she had no cognizable property interest in the enforcement of her restraining order by the police. And many of you will remember the profound sense of disappointment and frustration in the women's rights and civil rights and domestic violence advocacy communities after the Castle Rock case. It was the latest pronouncement from the Supreme Court following the DeShaney case and the Morrison case, which Vicki's referred to, that private acts of violence were exempt from constitutional scrutiny. So it was with this sense of frustration that Jessica and attorneys at the ACLU, which included myself at the time, decided to take this case to the international arena. We really wanted to highlight the gulf between this domestic constitutional framework on the one hand and international human rights law, which offered a vision for affirmative obligations where the police and the government needed to act with due diligence, as Lisa referred to protect individuals from violations committed by private actors in a very kind of simple equation. If the state knows or should have known that of a specific danger to a specific individual, it has a duty to respond and to protect. And so we brought this case to the Inter-American Commission. It was the first international legal case against the United States for violating the human rights of a domestic violence victim. Although the case represented this exciting principle for us, right, of affirmative obligations, there was really kind of a get real element to it. Yes, it sounded great on paper, but we're talking about an international body that probably many people in this room have never heard of, let alone the general public, and a lack of an enforcement mechanism for the decisions that come from that international body. And so even a positive decision, even the best possible decision we could hope for, would be relatively meaningless, at least domestically, unless we got political leverage and buy-in from the advocacy community, if not the general public. And to this end, my students, and by this time I was at Columbia teaching in a human rights clinic, and so my students and my colleagues and I engaged in what my colleague Suzanne Goldberg at Columbia calls multidimensional advocacy. So we tried to zealously advocate, for our client while pushing along with her for systemic reform through legislative advocacy, media advocacy, amicus brief strategies, and many of these strategies are continuing today, and I'm happy to discuss later on. But one of the things that happened was that we had this amazing amicus response. 90 amici signed on to 9 different briefs in support of Jessica's case, and the majority of these amici were legal services lawyers, private practitioners, or other domestic violence organizations that had little to no previous experience with international human rights advocacy. But this community was so taken with the international human rights framework and that they thought it really represented their vision of why they did their work, why they woke up in the morning, and the battles that they were fighting every day on behalf of and alongside their clients and partners. And this group of people then subsequently participated in a variety of international human rights endeavors, submitting shadow reports to the United Nations treaty bodies, participating and actually creating human rights panels at domestic violence conferences. We worked together on a domestic violence and human rights manual for legal services lawyers. And so this was, for me, an incredibly rewarding and engaging experience to be working alongside advocates on the ground to think about how these principles might actually be represented in their cases and in their work. But what I will note is that there was really a lack of institutional response to the case from the major domestic violence organizations in the United States. And I really felt the contrast. I was working at the same time on a case involving juveniles who were sentenced to life without parole, which kind of culminated recently in the Graham decision, Sullivan and Graham decisions before the Supreme Court. But we had a case before the Inter-American Commission which was focused on this practice of sentencing juveniles to life without parole. And there was this incredible coalition, nationwide coalition, who was focused on an advocacy campaign on this problem at every possible point that you could imagine. And this type of coordinated campaign, I just felt was quite absent from the advocacy community, the domestic violence advocacy community in the United States. At the same time that I was feeling but this kind of swelled enthusiasm but vacuum of institutional ownership over this issue, we had advocates from Latin America coming forward, and actually they submitted an amicus brief. 29 amici from Latin America submitted an amicus brief discussing the potential normative impact of the Jessica Gonzalez case for them at home. And given the recent decisions of the Inter-American Court in the Campo Algodonero case, which was against Mexico, where the Inter-American Court just in December affirmed for the first time states' affirmative obligations to respond to violence against women committed by private actors, and held that gender-based violence could constitute gender discrimination. That was a huge decision. The Inter-American Commission just came out with the Cara Natala versus Chile decision, finding that discrimination against a lesbian mother who had her children taken away in a custody dispute constituted a human rights violation. It's the first sexual orientation discrimination case. And then you had other cases from the European Court, Opus versus Turkey, for the first time the European Court holding the gender-based violence as a form of discrimination under the European Convention on Human Rights, the Bivacqua versus Bulgaria case holding that domestic violence is a public, not a private concern. So you have this groundswell of international jurisprudence that's really supporting a lot of the same principles that we're looking at in the Gonzalez case, and folks from Latin America saying, hey, your case is important to us too. And it was really kind of a very challenging moment in thinking about how to bring all of these voices together and how to think of this truly in a transnational way. So spurred by this Latin American amicus brief in Gonzalez and a similar amicus brief that actually we developed in the other direction, several of us who are part of a legal network called the Bringing Human Rights Home Legal Network, which is interested in the implementation of human rights strategies here in the United States, submitted an amicus brief to the Inter-American Court in the Campo Algodonero case, the violence against women case in Mexico, saying, hey, we in the United States care about this issue too. So we became really interested in thinking about kind of these bidirectional strategies and ways in which we could think about kind of transnational advocacy in a more holistic sense. And I want to just give Rhonda Copeland credit for a lot of these discussions, and she just enriched this conversation incredibly, along with so many of you in the room and many other people. And we began this series of conversations about the importance of this larger transnational dialogue. And we also sought to take a collective step back and examine the potential for a human rights approach to make connections between often siloed fields, reproduction, violence against women, sexuality, a lot of the things that Lisa was just describing. We really felt like all of these cases were coming down, and if we looked at them in their silos, sexual orientation, violence, reproduction, we were missing the forest for the trees. And so several of us, folks from Latin America and myself and several others, developed an idea of organizing a small inter-American gender justice convening to explore our common threats and opportunities in the field of gender justice, issues which are interconnected in both theory and practice, as this tragedy of feminicide on the U.S.-Mexico border makes starkly clear. But we also, and this is kind of part of my secret agenda, really wanted to use the convening as a potential catalyst for the revitalization of a women's rights or domestic violence movement in the United States. And I know others today will be talking about this. Perhaps using human rights as a place to foster a new network of advocates, or bring advocates who have been doing amazing work for so many years together in a new way, to think about how the international human rights framework might advance gender and sexuality advocacy and scholarship in the region. So it's been, I know I'm running very short on time. Let me just make 2 points. It's been a fascinating journey for me as a clinician and as an advocate and as somebody who's engaged in scholarship on this, to think about how you start with a U.S. domestic violence case, you reframe it as an international human rights case, and ultimately use that as a point of departure for pursuing larger coalition building, a larger coalition building project that really traverses both national and thematic boundaries. In the clinician's world, we often speak of the client-to-cause continuum, and we talk about how a clinician sometimes is forced to choose one or the other. Do you represent a client or do you represent a cause? And I think much like Clare Dalton's work, the Gonzalez case has shown that this is sometimes a false choice, that we can accomplish both, and that when we do, our teaching, our advocacy, and our scholarship, and the clinical experiences of our students are all the better for it. And I'll just end by also briefly mentioning, and I'm happy to discuss this later on, that the work on the Gonzalez case and the larger advocacy projects that have developed from it have also helped me to politically and ethically reconcile concerns that I've had about the human rights enterprise, replicating the very imperialist narratives and victim essentialization that we purportedly fight against. Human rights advocacy has historically been kind of in a very clear north to south direction, but by both domesticizing and transnationalizing human rights issues, especially in the area of women's rights, where the United States is always pointing the finger outside, I think we increase our credibility on the world stage and enhance the integrity of our work here at home. So thanks very much.
So thank the three of you for just tremendous, rich presentations. Thank you so much. So we have time for questions. I'm actually going to take even a little bit more time than we're supposed to have. I think we're supposed to end at 10:30, but we started a little late. So David Swanson, who is standing there, has a microphone. We're taping this, so people should raise their hand, and David will run over with the microphone. And David, you can also ask a question yourself if you want to. So you're not. But thanks, David, for helping out with this. So we've got a lot on the table here, and it looks like Margaret has a question. Yeah.
Hi, a question for Carrie. I'm wondering to what you attribute the lack of institutional advocacy support in the Gonzalez case.
Can you say your name, too?
Margaret Drew.
Others can speak to this as well. I don't have any sort of firm answer, but I do think that it has to do with the silos that I talked about. When I've spoken with a lot of the major domestic violence advocacy organizations in this country about the case, all are very concerned, and they've supported the case as amici and in consultations. But they've all said that they don't necessarily have space in their dockets or in their in their institutional priorities to take on all that this case represents. Now, many have also pointed to a problem of funding, where the most domestic violence organizations in this country rely significantly, if not predominantly, on federal government funding and other government funding, and so there's been a lot of criticism and commentary on kind of the movement becoming more of a service industry that's spurred and encouraged through these funding mechanisms. But I think others in the room can probably speak to that much better than I can. But the result is that I feel like in some ways such a fish out of water. Like why has our clinic not been able to, in some ways, kind of find an institutional partner who can do this much better probably than we can, and has a lot more kind of a vision of the place that this case occupies in a larger context.
Can I
Yes,
raise,
please.
just before we get to Zanita? I mean, because I hadn't really thought about the question, but I think that part of the difficulty, and I'm bringing this from experiences trying to move sort of the traditional civil rights and social justice organizations into a human rights frame of mind. I think part of the difficulty is law school, let truth be told, that human rights is deemed to be like an elective for upper class people who might have an interest in it, rather than, I mean, I come from it as a constitutional law professor above all else, and it seems to me Article 6 places it squarely within what I would consider to be what should be the core curriculum. And I know that there are changes, I think, Harvard probably is one of the places, who has moved in that direction to make it part of the core curriculum. But until we train lawyers differently so that they aren't able to treat human rights as if it's other and outside, but that it is just like con law, torts, contracts, et cetera, I think that may in fact be part of the difficulty. Because it's like extra. You know, people are saying, I'm here trying to make somebody's material existence. Well, they don't say it that way. Okay, I'm here trying to make somebody's life a little easier, and you're coming to me with like this extra stuff that's really nice, but I don't have time to do all of that. So I think maybe we have to do a better job at demonstrating that it's not optional, it's not extra, and it's a useful tool. And it's part of we contend, part of our domestic law. Self-executing or not, as far as I'm concerned.
I did. I think that these are terrific points, but I'm reminded, and I do think Harvard is moving in that way, and Georgetown a little bit as well. Mm-hmm. But so Judith Resnick has this really interesting paper, with the title of which is something like Law as Affiliation, in which she argues, she calls attention to the history of resistances to being told that U.S. law is drawn from someplace else or influenced by someplace else. Mm-hmm. And so another factor here, I think, to think about is it still completely surprises me, but it seems to be sort of one of these social facts that is very sticky, that there are places where if you say this is a violation of international human rights, it's meaningful and it gets traction. And there are places where if you say that, it has the opposite effect, the persuasive effect you're aiming for. And that's just a complication here that I thought it was worth having on the table.
Yeah, and people may have heard about the Oklahoma, for example, the ballot initiatives that just passed barring citation to international human rights law in state courts. So we have another question, Zanita? Yeah.
I'm Zanita Fenton, and this was a wonderful, rich conversation. I have a million questions. I'm going to try to restrain myself to just one. In fact, I'm going to try to pick up on one of Carrie's points about combining the silos. In responding, perhaps commenting on a point that both Vicki and Lisa made, or at least in my mind, they both made it. Because I know the Nguyen case also, and Lisa spoke a lot about the use of sexualized violence in war contexts, and it seems to me that combining the two of them together gives us a dynamic where we've got this, I'll put in quotation marks, responsibility paradigm that not only enables but encourages men to have sex, to commit rape without responsibility, and it's more intensified because of the transnational context. And my first response in thinking about Nguyen is also to add the layer of otherism, that is racism, that comes in part with our understanding of immigration laws, that it's okay for immigration or for people to immigrate if they're same. But when we're talking about war contexts, we're talking about warring with people that we don't like, that we want to be away from. So of course we don't want them coming here and to give them an extra avenue to do so through paternity. If you can find a question in there. Thanks.
Yes. Yes, absolutely. Yes.
Thank you, Lisa.
Yeah, I think Margaret Burnham has a question. We'll come back. I'm sure we'll circle back to that.
My name is Margaret Burnham, and I teach at this law school, and I want to, first of all, thank all of the panelists for just an incredibly rich presentation. I have actually two questions, and I'll make them kind of quick. First, to Professor Jackson, I know the answer to this question is by my book, but I do want to know what you think prescriptively of this conundrum that you've presented, that it's almost impossible to make comparisons if you're sort of situated, you're well situated in your own regime and don't really know what's going on in these other regimes. And moreover, there can be lots of other regimes, some of which are with you and some of which are against you. And so comparative work, comparative constitutional work is impossibly, perhaps not impossibly, but extremely difficult. So then what is, where does that land us? And then for Professor Crooms, I just wanted to say that I appreciated your linkage between sexual violence and violence against women. And in part, I think that the whole notion of sexual violence being something that should be addressed in human rights comes from the development of international criminal law, and of course the work of Rhonda and others in making clear that these are violations that can be committed by individuals in the context of war, and that they can be held therefore responsible. So it's part of the anti-impunity movement with respect to all war-related, human rights-related, humanitarian crimes. And so that seems to be like a boundary that it's important to maintain in some ways. And I wonder what you think about, your argument that these are so similar that they ought to be recognized as such in human rights jurisprudence, I think perhaps misplaces the importance of criminalizing international war-related crimes by individuals, which is itself a huge leap in international law over the last maybe 20 or so years.
I'm still thinking about the wonderful comment from there, and I think it's just very insightful and thinking about the books that one could write on it. So thank you. You've asked, Margaret's question to me is a terrific one, and I could say, yes, I've struggled with this, so I wouldn't mind if you bought the book or at least asked your libraries to. But I think I do not share the pessimism about learning from comparison that strong versions of the observation of the particularities of individual systems would lead one to. There are folks in the world who really think there's nothing one system can learn from another in a certain sense because each one is so embedded, particularly public law systems. I don't share that. I just think it is hard and that you need to be cautious, and that actually scholars have a very important role in spending the time to figure things out so that they're usable in responsible ways by advocates and by judges. But I really don't think there is a choice. There are so many settings now where courts and tribunals are being asked to essentially make translations. Think about, refugee claims and understanding whether rape will be prosecuted, whether women can get protection in another country, or the nature of political persecution. Think about extradition. Since the Saurian case in the European Court of Human Rights, it has been almost impossible for the United States to extradite anybody to face criminal charges from Europe, and since another case from Canada, to face the death penalty. And as those tribunals move towards more stringent standards for the review of punishments like life without parole, our criminal justice people, our prosecutors, have to understand it to be able to do their jobs. The amount of transnational communication about law that we are becoming enmeshed in is huge. A stunning example to me is that in a trial in the Southern District of New York of someone in some terrorism-related offense tried in a regular Article III court. The person was obtained from South Africa without getting assurances that the death penalty would not be sought. And the South African Constitutional Court, after the person had departed, issued a judgment saying, this violated our Constitution. Under our Constitution, we would not have allowed this person to be moved to New York if we'd understood what was going on, and we request that our judgment be conveyed to the court. So a diplomatic thing happens, the judgment is conveyed, I think it was Judge Sand, in the Southern District of New York. Defense lawyers seek to put the South African court's judgment before the jury in the Southern District of New York, and Judge Sand permits it. And the jury refuses to bring in a death penalty. One of the very strong arguments made was that in the view of the South African court it would be impermissible and that another defendant had been procured, but with the assurance of not seeking a death penalty. So one of the answers is we need to do it, We need to develop the understanding. And it is possible, it just takes a lot of work. But remember, when someone asks you, what's the U.S. law on? In any area where there is contest, one, as a law professor, would give a kind of complicated and nuanced response, well, on the one hand and on the other. And so we shouldn't be surprised to find that when we get to other legal